Hi everyone, I'm immigration attorney Yasin Akalan. Last week we started diving into Donald Trump's latest immigration orders and the chaos they've stirred up. Today, we're continuing with the next wave of critical updates. These policies are rolling out fast, and I'll break down what they mean for you or your family and your immigration process. As always, things are changing so quickly in the immigration world that by the time as you watch this, new developments might already be happening. But for now, let's focus on the most urgent updates. So let's get started. If you entered the US through the Mexico border with parole using CBP-1, listen up. You might recall how much Trump opposed the CBP-1 system. Just search CBP-1 and Trump on YouTube and you'll find tons of videos on the topic. DHS's latest announcement backs this up and specifically targets those who entered within the last 2 years. Parolee statuses are now being re-evaluated. ICE officers appear to have the authority to revoke your parole, and if you haven't filed for asylum yet, you may face expedited removal. If you haven't submitted your asylum application yet, this is the time to act. DHS is focusing on quickly removing weak or incomplete cases from the system. But don't panic. No one's likely to show up at your door tomorrow. But don't delay taking action. Protect your future by acting now. What should I do if I encounter ICE or they come to my door? The steps you need to take depend on your situation. Here are some key scenarios to consider. Those with a final removal order or a criminal record. If you have a final removal order or a criminal record, ICE can detain and deport you or place you in custody for legal proceedings. That is why it's critical to consult an attorney before ICE shows up at your door. Individuals with pending applications. If your immigration application is still pending, having proof of your pending case can make a significant difference. Make sure to carry documents such as USCIS receipts proving your application has been received, court notices or documents with your upcoming hearing dates, employment authorization document EAD. For green card holders, if you're a green card holder, always carry your green card with you. This is essential for proving your legal status quickly. An important note, if ICE comes to your home, they often request permission to enter. If they're asking for permission, it usually means they only have an administrative order, which does not give them the authority to forcibly enter your home. Always ask to see their identification and whether they have a judicial warrant. If they do not have a judicial warrant, you're not required to let them in. Knowing your rights and seeking legal support when necessary is the best course of action in these situations. Have you heard about the new changes to expedited removal? The Trump administration has expanding its scope, and if you entered the US within the last 2 years, this could impact you. So let me explain how. Who is at risk? This applies to those who entered the US on parole or without inspection after January 2023. How does the process work? There are two main groups. One, no pending court case. If you don't have a pending court case, your process might start with a credible fear interview. So they will check if you have a valid reason to stay or if you have a weak case. If you pass the interview, you'll have a chance to present your case in court. But if you do not pass, you might be deported. Or you can ask for a judge to review your credible fear interview finding. But if the judge denies it as well, you might again face deportation. Second scenario, if you have a pending court case. If you already have a case in progress, the timeline might speed up slightly. However, the outcome and the speed largely depends on the judge and the prosecutors, meaning the trial attorney's approach. This expedited removal proceedings mainly target recent arrivals with weak or incomplete cases. If you have a strong case and your documents are in order, you are likely safe. Stay still prepared and informed, and as always, rely on trustworthy sources and protect your rights. USCIS has officially removed the COVID-19 vaccination requirement for green card applicants. Starting January 22nd, 2025, you no longer need to submit proof of COVID-19 vaccination with Form I-693. This means no more concerns about receiving a request for evidence (RFE) or having your application denied due to missing vaccine documentation, meaning for COVID-19. If you're planning to apply for a green card, now is the perfect time. Contact us for more details and guidance on the process. That's it for this week. Remember, the immigration world is moving at lightning speed right now, and it's more important than ever to stay informed. If you have questions about how these changes might impact you, drop them in the comments or reach out to me directly. Don't forget to like, share, and subscribe to stay updated with the latest news. And of course, stay tuned. There is always more to come. See you in the next video. Take care.